Hi, Austin divorce lawyer Ben Carrasco here today to talk to you about some of the factors to look for when you're hiring an attorney. So let's go ahead and get started. Number one, Google rank does not necessarily correlate with attorney quality. So if you're like most consumers of legal services, you're probably going to begin your search by conducting an online search. You're going to pull out your phone or your computer and you're going to search Best Divorce Lawyer Austin or Austin Divorce Lawyer near me. And the natural inclination is going to be to assume that the attorneys that appear at the top of your search results represent the best attorneys in Austin for what you're searching for. And that is not necessarily the case. Most attorneys, those who market aggressively, have marketing agencies and firms working on their behalf to produce content and obtain backlinks and other signals of trust to ensure that they appear, or to at least help them appear at the top of those Google search rankings. But that does not necessarily mean that they're the best attorneys. That might signal that they're the best marketers, that they have the best marketing agency working on their behalf, but it doesn't mean they're the best attorneys in Austin. Some of the finest attorneys are those who receive the majority of their referrals, for example, from word of mouth. They're not investing in Google search. They're not hiring marketing agencies or SEO companies to ensure that they're at the top of Google, but they may nevertheless be very good attorneys. So again, don't assume that simply because an attorney is a good business person, has a good marketing agency working on their behalf, is producing good content or videos like this one. Now, obviously, I'm the exception. I'm an attorney that invests in marketing, and I also happen to be very exceptional. Take that as you will. But again, simply because they appear near the top of the results does not mean that they're the best attorney. So just keep that in mind. Number two, bigger is not better. If you're looking for an attorney, you're going to see options between solo practitioners. You'll see law firms with multiple attorneys working at the firm. And you might assume, particularly if you have a more sophisticated or a high conflict case, or maybe you're a high net worth individual, it is tempting to assume that hiring a bigger law firm, a firm with more resources, is going to produce a better outcome in your case. And I'm here to tell you, based on my personal experience, based on my experience dealing often with bigger law firms or firms with multiple attorneys, that that is certainly not the case. What you can reasonably assume is that bigger will translate into bigger legal fees for you. So let me just explain briefly how our business model works. Most family lawyers, we're not like personal injury lawyers. We don't get a percentage of a settlement. We don't get a percentage of your community estate. We don't make offers like no fee unless you win. We bill by the hour. And as you can imagine, a billable hour model is not necessarily aligned with your best financial interest. Our incentive is to bill more hours. That's how we generate income. That's how we make money. The more hours that are billed to your case, the more profitable the case is for the attorney. So if you have a bigger firm, that means you're going to have more timekeepers. You're not only going to have the partner or the lead attorney who is assigned to your case, you're going to have potentially an associate. You may have at least a couple of paralegals. You may have legal assistants. If it's a bigger firm, they probably have a larger, more expensive office space. They have a more substantial marketing budget. All of those costs have to be paid for by someone, and that someone is you. So if you hire a bigger law firm, when you get your monthly invoices, you're going to see charges not just for your main attorney, but all these other timekeepers, the paralegals, the associates, the legal assistants, often spending time simply communicating amongst themselves and not necessarily advancing the ball on your case. So when you're evaluating law firms, bigger, again, is not better. The quality of the attorney that is assigned to your case may not be that great, and that is an important consideration and question to ask when you're interviewing a law firm with multiple attorneys is, who is the attorney that's going to be assigned to my case? The attorney that's on the billboard, the attorney that appears in the TV ad, the attorney that appears on the ad on Google, that is the face of the law firm. That could just be a very effective business person who has stopped practicing law long ago and focuses primarily on business development. And then when you hire that law firm, they're going to shuffle your case off onto some wet behind the ears junior associate who's fresh out of law school. That's not the person you want handling an important and sophisticated family law case. So it's imperative when you're interviewing a law firm make sure you know who is the attorney that's going to be representing me, and then do your own due diligence on that attorney. Look at where they went to law school. Look to see if they're board certified. Look how many years of experience they have. Try to figure out how many final trials that they've handled, whether they've handled a case that's similar to yours, whether they're familiar with the judges in the county where your case is going to be filed. You want to be able to interview not just the law firm, but the specific attorney that's going to be handling your case. And don't be afraid to push back and ask questions to get that information when you're interviewing the lead partner or whoever it is that is handling your intake. Number 3, board certification. In Texas, attorneys can become board certified in a variety of areas of the law. And that certification process is overseen by an organization called the Texas, or an entity called the Texas Board of Legal Specialization. You can Google them, you can look them up, you can go to their website, and you can select the county in Texas where your case is going to be pending and click on family law, and you can see all the attorneys in Travis County or Williamson County or Hayes, wherever your case happens to be. You can see all the attorneys who are board certified in family law. What board certification means is that the attorney has gone through a rigorous screening process. It means the attorney has met certain practice requirements. For example, in order to become board certified in family law, you have to have handled a specific number of final trials that deal with custody issues, a specific number of final trials that deal with property division. You need to have handled a certain number of mediations, and you need to have either served as first or second chair on a jury trial or written a appeal. So unless you've fulfilled those requirements, you can't become board certified. And the final step in achieving board certification is passage of a rigorous blind graded written examination. So for example, I know a number of attorneys who have fulfilled the practice requirements. They've had the requisite number of mediations. They have the trial experience. You also need, by the way, peer reviews from your peers within the community, as well as I think 2 to 3 judges. So they may have all those requirements, but they fail the exam. I believe it depends on the year, but only about 40 to 50% of the persons who sit for the exam actually pass it. So board certification does not necessarily mean that your attorney has won all their prior cases. There's no investigation into the results of the cases that you've presided over, you've served as first chair on when you're submitting your materials to the Texas Board of Legal Specialization. But it does at least demonstrate that the attorney has a certain level of competence within family law. They know the substance of the law, they've passed the exam, they have the requisite experience to handle your case. So all things being equal, if you're choosing between an attorney that is board certified and one who isn't, probably a safer bet for you to go with the attorney that has board certification. Number 4, this I call promises. Keep in mind, if you likely know this already, lawyers have a bad reputation for a reason. We make promises that we often can't keep. And if you're meeting with an attorney and they are making promises to you about outcomes in your case, they're saying things that just sound too good to be true, it probably is. And let me give you a classic example that I've heard from people that come and interview me. They may have met with another attorney, and the other attorney tells them, let's say you're a dad, and the attorney tells them, hey, no problem, I can get you 50-50 possession of your children and no child support. Okay, that is highly, highly improbable. That rarely happens. That is a pie-in-the-sky scenario. If an attorney is telling you that, run. That attorney is lying to you to get you to pay the retainer, period. Not to say that it never happens, but if that happens, 50-50 possession and no child support, it happens because your spouse agreed to it, not because you have this brilliant attorney who went in front of a judge and made an argument and convinced the judge that that particular arrangement was in the best interest of your children. We have a law in Texas about what schedule is presumed to be in the best interest of children. It is not a 50-50 schedule. It is rare that judges do not order any child support. I don't want to get too off topic here. I have other videos that address those points. But the point is, if you have an attorney that is telling you things that don't seem to square with the law, with what other lawyers are telling you, that's probably not an attorney you want to go with, because you can end up investing tens of thousands of dollars in your case with an expectation that you're going to achieve a certain outcome. You go to court, you don't get it. What is the attorney going to do? He's already been paid. He's going to just shrug his shoulders and blame it on the judge or blame it on you. Another example would be if an attorney tells you that it's easy to move to another city with your child. I have clients that come to me, they're in Austin, but they've got family in Dallas or perhaps some other state, and at the end of the divorce, they want to be able to move with their kids to another location. And I can tell you that most judges in Central Texas, most judges, period, regardless of where you are in Texas, are loath to let parents move out of the immediate area with their children. So if a lawyer is telling you during the consultation that that is an easy objective to achieve, again, another example of somebody who's probably lying to you to get your money. That is not a positive way to begin the attorney-client relationship. You want somebody who's going to level with you. If anything, you want an attorney who's going to underpromise and overdeliver. That's the way I practice law. If anything, I'm overly pessimistic about potential outcomes because I want to keep my clients' expectations in check. I want people to have reasonable expectations about what is achievable. And if we can get a great result, all the better. But the advice you get ought to be grounded in what we actually see judges do and what the law is and what the presumptions are in the law. If you have a lawyer that's telling you things that just, again, don't seem to square with what you're hearing from other attorneys, I hesitate to say your online research, but there is valuable information, free information you can find on my website and other websites that can at least give you a surface level sense of what the law is in Texas with respect to a variety of issues. So be wary of lawyers who seem to make promises that don't seem realistic. Number 5, trial experience. There's a lot of lawyers who emphasize settlement, and settlement is a worthy goal. I think settlement is where most cases ought to be resolved, but you want to have an attorney that is capable of going in the ring and fighting for you and your kids and your assets if you're dealing with an opposing spouse who's not being reasonable and who simply won't settle. Some cases need to be tried, particularly, to use the example I already mentioned, if you want to move. If you want to move to another state and you've got good facts on your side, you can ask for a jury trial. Juries are more sympathetic in general to letting parents move. So you want an attorney that has real trial experience and is capable of making that argument, has the skills to do it and the willingness. Some lawyers, and I don't know why they're in this field because this is a trial-intensive field, but they're afraid of the courtroom. They're not prepared. They're not comfortable on their feet. They don't know how to cross-examine witnesses. They want to just be in a conference room or on a Zoom call and get everything settled and then move on with their day and go to happy hour. That's not the way I practice law, but that's unfortunately what I see a lot of my colleagues, that is their propensity. So when you're interviewing an attorney, ask them, what percentage of your cases go to trial? How many cases have you tried in the last year or 2 years? Make sure that they have trial experience in the county where your case is pending. My office is in Travis County, but I am routinely in Hays and Williamson counties, so I'm familiar with the judges up there. If you're interviewing an attorney in Austin and your case is going to be in Williamson County, make sure and ask them, are they familiar with the judges up there? Do they know their tendencies? Are they taking cases to trial? That's an important consideration because, frankly, any lawyer can settle a case. Waving the right flag, agreeing to things, that doesn't require a lot of skill. There's other lawyers who may disagree with me and say, oh no, there's a skill and an art to negotiation, but sitting through the mediations where you're simply exchanging offers back and forth and the mediator's writing it on a Word document and you've got a spreadsheet with assets and you make some adjustments and tinkering to the numbers, that's not a heavy lift intellectually. That doesn't require a lot of creativity. It doesn't require a lot of preparation. It doesn't require the ability to stand up in a courtroom in front of a judge and make a persuasive and compelling argument. We don't make arguments to mediators. We talk to them, we vent, we tell them our position, but it's wholly different than going to a trial and battling out in the trenches. So you want a lawyer who's been battle tested, somebody who can move to a wartime footing if the needs of your case require it. Number 6, billing practices. This is a tough one. A lawyer can say anything in a consultation, tell you what you want to hear, and some things you're just not going to know until you engage the attorney and the representation begins. But at least ask for a ballpark figure, like if the case is amicable, if we simply have to do some limited discovery and go to mediation, what's that going to cost? Usually I try to give my clients a ballpark figure for that scenario. If the case is more contentious, high conflict, it's much harder to predict what the total cost is going to be. But I can tell them, based on other cases I've had that have gone to trial, what was spent. So at least they have a rough sense of what the cost will be. And it's important to also inform you that you don't know what attorney your spouse is going to hire, and their billing practices may be different. It may be a bigger firm, and they may spend exponentially more than you'll spend hiring me or someone else. So all the lawyer can tell you in the consult is what he or she might be able to anticipate about their expenses, not the expenses of the opposing attorney, unless they have familiarity with the law firm. You also want to ask them, do they bill in 6-minute increments, 10-minute increments, 15-minute increments? Most lawyers, I would say, do 6-minute increments, but some do 10 or 15. That means if I spend 2 minutes on an email to you, I do 6-minute increments, so 0.1 is 6 minutes. But if they do 10 or 15, that means you're going to be spending more money. And that can add up over the course of a 6-month or a year-long engagement. That can result in significantly more legal fees for you. You also want to ensure, and this is something that will likely be spelled out in the fee agreement that you sign with your attorney, but you want to make sure that the lawyer sends you invoices regularly, at least once a month. And those invoices need to clearly show the activities that were performed, because everything we do is essentially billable. Phone calls, meetings, trial preparation, gathering evidence, reviewing evidence. Any time that we spend in your case is billable, and you want to have invoices that are transparent and clear and what reflect what not just the lawyer, but any other timekeepers, if there's a paralegal or an associate on the case, how much time they're spending as well. And don't be afraid to ask questions if you feel like you're being fleeced or taken advantage of. Again, something unfortunately that I see a lot in this community. It's one reason why clients change lawyers fairly regularly in family law disputes, is they feel like they have an attorney that's not responsive or who's simply taking advantage of them from a financial standpoint. But if you have a phone call, for example, with your attorney and you have your iPhone records, it shows you spent 15 minutes on the call, but you get an invoice and you see the date of the call on the invoice from the attorney and it was an hour, well, something's wrong there, right? You're being overbilled. Ask questions about it. It's illegal to do that. So don't be afraid to challenge and push back your attorney if you find yourself in that situation. Number 7, reviews. A lot of lawyers have reviews nowadays. A lot of lawyers have very positive reviews, and I can tell you that unfortunately not all of those reviews are authentic. There are lawyers who will, I'm not going to name any names here. I wish I could, but I don't want to get sued. But there are lawyers out there who are telling their employees to go ask their friends to leave reviews for the law firm. I know of attorneys who are getting reviews from ex-girlfriends, which you'd think they'd be getting bad reviews, but sometimes they get good reviews from those folks, or current girlfriends, what have you. The point is, they're bogus, they're fake, and you don't really have any way of knowing. Now, on a Google review, the name is there. And I had a client interview me last year who actually, I guess, Googled some of the people in my Google reviews and reached out to those folks to confirm that I represented them and to get feedback from them. I had some former clients reaching out to me, letting me know that this person was asking them questions about me, and I didn't have anything to hide. These were people that said positive things about me. But there is a database that you can research cases and by attorney name or client name. So if you see a client name in a review, you can look them up, whether the case is in Travis County or Williamson, and confirm that the lawyer represented that particular individual. Another thing I would look for is there's a fundamental difference between a perfunctory sort of 3-sentence generic review that says this is a fantastic lawyer who did a good job, and a review that reflects real time and effort, that's effusive, that has multiple paragraphs, and really strongly praises the work that was performed by the attorney. That's a review that I think is more trustworthy and reliable than something that's just a few sentences long and seems kind of generic. And also look for content in the reviews that talks about whether the case actually went to trial and how the attorney performed in court. A lot of reviews are from clients who settled their case and they think they got a great deal, when in reality they got kind of a run-of-the-mill agreement that's in line with what we typically see. Nothing exceptional about it. But if the review talks about having a trial and the way that attorney performed in trial, then I would say that's a more reliable review. That's a good indicator that the attorney has good trial skills, which is an important quality you want to look for in the attorney that you ultimately hire. Number 8, rates. We're all price sensitive, especially in this economy. And I would simply say here that bigger is not better. More expensive is not always better. I know some attorneys that bill at extraordinarily high rates who are frankly mediocre. Again, I'm not going to name names. I know some attorneys that bill at high rates who are good. And I know some attorneys who have more modest rates who, again, some are good, some are not. It's kind of a crapshoot at the end of the day. I mean, all of these things I'm talking about here, you could seemingly go through this checklist and have a negative experience with the attorney that you hire. And that's one reason, again, why it's fairly commonplace to see clients change attorneys during the course of the representation, which, by the way, does not necessarily hurt your case. It can hurt you in the sense that when you hire a new attorney, you got to pay that lawyer to get brought up to speed. They're going to have to review the case file. Changing horses in midstream can always create some challenges. And how significant the challenge is really depends on the timing of the case. It's better to change lawyers earlier on in the case than, for example, 3 or 4 days before a final trial. Hard to see how your best interest would be served by changing lawyers that late in the game, although you could ask for a continuance. But the point being, if you're not getting good results, your lawyer's not responding to you, your lawyer's not shooting straight with you, you've already seen the lawyer at a hearing and their performance was not very confidence-inspiring, then you probably should hire someone else. But don't think that a judge is going to judge you harshly because you've changed lawyers. Now, if you go through 4 or 5 or 6 lawyers over the course of your representation, then that is more indicative of a problem with the client, frankly, than it is the attorney. But changing lawyers once, maybe even twice, depending how long the case is not going to be perceived as a red flag by the judge when you end up going to trial. So again, back to the rates and consultation fees. Rates are sort of all over the place. I would say in Travis County, most lawyers are between $400 and $800 an hour. That's for a partner. Associates may be less expensive, or a sole practitioner. If you're going with a bigger firm, they're going to try to sell themselves by saying that, well, yes, the partner has this astronomical high rate, but the associate who has a lower billing rate is going to be doing most of the day-to-day work on your case, and that is going to be their pitch to you for keeping costs contained. My experience, again, with bigger firms is even when they're making that pitch, it doesn't work. You still end up paying more. You'll have a final trial in a case like that, and you've got a partner who's billing $700 or $800 an hour, and they're in court, and they bring their associate to the trial who's billing $400, and they've got a paralegal who's billing $200, and those people don't make a peep. They don't do anything except maybe hand some binders over, and yet you're being billed for that additional labor when it's totally unnecessary for your case. It's just another example of how these big firms take advantage and fleece clients. So you want to make sure you interview multiple attorneys, look at their rates. Don't assume that a lower rate means you're going to spend less money, because sometimes lawyers who bill a lower rate make up for it by just billing more hours to your case, which is unethical, but this is likely your first exposure to the legal system. You don't know how long these tasks that lawyers perform should take, and you're in the dark, and lawyers unfortunately take advantage of that. Consultation fees. Another issue that comes up often is the debate between a free and a paid consult. I do not offer free consultations. I think when you don't value your time, neither do other people. And the benefit of a consultation is tremendously valuable. You gain a lot of important information during that 30 minutes or an hour that you meet with an attorney. You get an assessment about the strength of your case. You get a good overview of the law in Texas. And it may make or break whether or not you decide to file for divorce. So I think it's worth it to invest and spend the money on an attorney who's going to be giving you that feedback. Often these free consultation firms, you're not meeting with an attorney. If you are meeting with an attorney, it's probably not going to be the lead attorney on your case or the attorney that is going to handle your case if it goes to trial. It's going to be a junior attorney or some intake specialist or perhaps even a paralegal. Because lawyers are too busy. We don't have the time to just be giving our time away for free during the day. If we do have that time, then we're not in very high demand and we're probably not very good at what we do. So a good attorney is usually an attorney that's in high demand and simply doesn't have the capacity to give away free time 4 or 5 or 6 hours a day on consultations that may not pan out and result in an actual signed client. So I think it's worthwhile if you're looking at a free consult versus an attorney that's charging for your time, no problem with interviewing both, but I certainly would not be dissuaded from talking to an attorney if you're going to balk at paying $400 or $500. If you don't have $400 or $500 to meet with an attorney, you don't have $7,500 or $10,000 for a retainer, you're probably not serious about filing for divorce. You're not ready to file for divorce, and you're just a tire kicker. And I don't want to meet with tire kickers. So that's my view of it. Others may have a different view, but it is a consideration. Number 9, empathy fit, right? Rapport. You may be tempted to go with an attorney that you like. In family law in particular, clients won't say it, but they are looking for a surrogate therapist. Somebody who's going to, I'm going to hold your hand. Oh, he's such an SOB. We're going to take him to the cleaners and it'll be okay. And you'll bounce back from this. Oh, let's be friends. I don't operate that way. Okay. People hire me. They want a bulldog. They want a Doberman. You don't buy a Doberman and then try to turn him into a lapdog or a golden retriever. If you want an aggressive bulldog junkyard lawyer, that lawyer may bite you from time to time. They may be a little bit abrasive, not always the most pleasant person to deal with, not somebody you might want to have a beer with at the end of the day. But if you want somebody who's going to rip your spouse's throat out, that's kind of the lawyer you want to have. If you want somebody who's not going to be afraid to go to trial and has the chops and the experience to go to court and make an argument, might not be the nicest person on the block. Now, that doesn't mean that they shouldn't be ethical, doesn't mean they shouldn't be responsive, it doesn't mean they shouldn't work hard on your case. But point is, you're not hiring a friend or a therapist or somebody to hold your hand. You're hiring somebody to fight for your interests and ultimately win if you go to court. And no, I don't believe that there's no winners in divorce or family law. Okay? If you want to move to another state and you go to trial and you get to move, that's a win. If you believe it's in your child's best interest for you to have a majority of the possession time and you get that, that's a win. Somebody won. Now, there's collateral damage associated with divorce. There's expense associated with divorce, and perhaps in a more abstract sense, sure, nobody wins. But when I go to trial, I've got a list of proposals to the court, rulings I want the judge to make. And if I can get more wins in terms of the rulings that I want on behalf of my client, then I perceive that, and my clients generally perceive that, as a win for them. So, again, rapport is nice. It's nice to be able to like the person that you're working with, but those things should not trump experience, credentials, and the ability to deliver the result that you're looking for. And sometimes you have to hire unsavory people to do that. So I hope you found this helpful. And if you have any questions, if you want to schedule a consultation with me, feel free to go to my website, bencarrascolaw.com. Thank you.